On the record in the matter of the state of Michigan versus Exavania Bolin, file number 25-01232. Yes, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people. I would like to make a motion to practice under Michigan Court Rule 8.120.
Exaviana?
Xavier.
Xaviana, okay. Today was the date and the time scheduled for preliminary examination for police officer Plea and eluding. Are we proceeding today?
Yes, Your Honor, this will be a plea. I don't know if I put my name on the record. Aaron Robinson, Assistant Public Defender for Ms. Boland.
Okay, very good. I do see a plea sheet here. It says the defendant's going to plead guilty to reckless driving and consents to HYTA status. Is that accurate?
It is, Your Honor.
That's what you want to do, ma'am?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth on the penalty of perjury? If you could put your hand down. This form is the advice and rights and plea information sheet. If there's a signature page here, is that your signature there?
Yes.
Okay, are you missing something?
No.
Oh, okay, okay. And so you went over these rights with your attorney, correct?
Yes.
Okay, and you want to give up these rights in order to accept the offer?
Yes.
Okay, so that means that you're going to give up or waive your right to the presumption that you are innocent. So you're innocent until proven guilty, and you can maintain that innocence and require the prosecutor prove your guilt by taking this matter to trial and making them prove each element of the charge being brought against you beyond a reasonable doubt. Understand that?
Yes.
You also have the right to question or cross-examine any witness that they intend to call to testify against you, the right to call your own witnesses that will testify on your behalf, or you can present evidence that you believe show a defense to the charges being brought against you. You also can waive your right to silence and testify at your trial, or you can maintain your silence and then they can't use that against you. You understand that? You want to give up each of those rights today?
Yes.
Anyone threatening you to do that?
Yes.
Who's threatening?
Oh, no. Okay.
Okay, any promises if you give up those rights? Okay, and you're not on probation or on parole, are you?
Not right now.
Not right now?
No.
Okay. Do you have another case pending other than this?
No.
Okay. As to reckless driving, how do you plead?
Guilty.
Are you sure?
Yes.
Your body language doesn't tell me that you're sure.
I'm sure.
Okay. And you're pleading guilty because you believe you're guilty?
Yes.
Factual basis, counsel.
Yes, Your Honor. On April 26th, or excuse me, on April 25th at 100 hours, were you in the area of, I believe it was Cedar Street, Rotary Park area?
Yes.
And in the Rotary Park area, were you driving a Chevy Malibu at the time? Oh, a Chevy Cruze, excuse me. So you were driving a Chevy Cruze at the time.
Yes.
Gotta answer out loud for the record. And during that time, there were two police officers that were parked with their lights on, blocking the entrance to Rotary Park, correct?
Yes.
And you drove around them when their lights were on over the curve, correct?
Yes.
Any questions from the prosecution?
None, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing July 17th. When you leave here, you'll go down one floor and meet with probation so that they can get you set up for a pre-sentence interview. And they'll schedule that at another date, but there is paperwork that you need to complete before they can schedule that, okay? And they'll also advise as to your status or eligibility for HYTA for your sentencing.
I'm sorry, Your Honor, can you repeat the time?
It's gonna be 9 a.m. on July 17th.
Thank you.
Have any questions at this time, Ms. Rowland?
No.
Any additional matters for the record?
On behalf of the people, Your Honor.
No, Your Honor, thank you.
Thank you. Hang tight, we'll get you downstairs in just a moment. For the record in the matter. Mr. Freeman, record in the matter of the state of Michigan versus Shakira Jackson, 25-01270.
Your Honor, Haley Fortuna Gill on behalf of the people.
Your Honor, Brett Blackman on behalf of Mr. Jackson, consider it right outside. Here.
Here, Mr. Shakira Jackson. There was a date scheduled for a preliminary examination for controlled substance delivery, manufacture, and a police officer assault resist obstruct. How are we proceeding on this?
I was detained yesterday. For the stipulation in my appearance in this matter, I talked with my client about the 21-day rule.
We can't hear anything you're saying.
Okay, I talked to my client about the 21-day rule, and he understands that we would ask the court to allow him to waive that. Talk with the prosecutor, they have no objection to scheduling the date.
That's correct, Your Honor.
Okay. Okay, so Mr. Jackson, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned. And due to the fact that you recently retained Mr. Blackman, are you willing to waive that timeline? Okay, anyone threatening you to do that? July 17th work for you, Mr. Blackman? At 8:30.
July 17th, for preliminary examination?
That's correct.
Yes, thank you.
July 17th at 8:30 is will be your notice to appear. Any additional matters for the record?
None on behalf of the people, Your Honor.
None on behalf of the defense. Thank you, Your Honor.
Bond that's set will continue. You're all set. Okay, let's see. Mr. Sarcher here on behalf of Cameron Anderson, but I don't know that Mr. Carter is here.
That's correct, Your Honor.
Okay, are we expecting to run that?
My understanding, Mr. Carter was running a little bit late this morning.
Okay, are we running that?
Your Honor, we're running the exam on Mr. Anderson for the CCW. We do not have a victim here for the carjacking.
Sounds good.
Thank you, Your Honor.
Thank you. I saw Mr. Freeman in the hallway. I have not seen Ms. Schroeder or Mr. Milks.
Mr. Mills is across the hall, Your Honor, 200 Drive.
He's what?
He's across the hall.
Oh, is he on the record at all? Yeah, it looked like they was looking, patent needs an adjournment. Correct. Okay, and then Mr. Austin, you're representing Love.
Yes, Your Honor.
Are we running an exam on Love?
No, Your Honor, that'll be a request for adjournment.
You have a radio. You know it's supposed to be. Yeah.
Are you safe from the storms, Your Honor?
I was safe, but I can't say the same for my neighbors, and it's this a massive power outage, and who knows when the power will be restored.
Oh, so sorry. You're out of power? Just your neighbors?
I just want her to let the
Sorry, I distracted you.
Mr. Mills.
My
There is
bead.
much is coming. I just want her to let
You like-
tell Yolanda to bring love up.
Yeah.
Okay, let's see, Mr. Basiga, you have Darlene, are we running an exam? Oh, Yolanda's back now. I was trying to get her to radio you. We need love. Brought up. All right. And Basiga.
Yes, good morning.
and Darlene, are we running an exam?
We are, Your Honor.
The people do not have the necessary witnesses.
Well,
Okay,
that's
and
what
then
I'll-
we'll need,
Sorry.
you have one?
Yeah.
Oh. Okay, so we need love and Darlene.
No.
Love and Darling.
I run, we're not doing that, no. I appreciate that, thank you.
Okay, on the record in the matter of the state of Michigan versus Lindsay Patton, 25-00691, appearance please.
Good morning, Your Honor. Haley Fortuna Gale on behalf of the people.
And good morning, Your Honor. Stephen Mills on behalf of Patton's present and sitting to my right this time.
Mr. Patton is scheduled for a preliminary examination today. And we adjourned this previously because additional discovery was being sought. Did you get your discovery?
Yes, Your Honor, we did receive, we requested the affidavit. We also requested body worn camera. To my knowledge, we've not received any sort of body worn camera at this time. However, we did receive the affidavit for search warrants.
What's the status of the body cam?
Your Honor, I would have to look into it. I'm not sure why the defense hasn't seen the body worn camera. or hasn't received the body worn camera. I think I said seen. But I will definitely look into it and make sure that he gets it immediately. I did put in a request, so I'm not sure what the issue is there.
And the only thing, Your Honor, I would say is, because there's several agencies involved, I don't know if it's going through a different means than usually get it through evidence.com, a link. But I mean, at this point, we don't have any of the body worn camera, but I don't know if it's just brought in differently. However, my understanding is that the people wouldn't even be prepared to proceed today if we did have all the evidence.
Is that correct?
That is correct, Your Honor. That being said, it's
Why?
my first priority to make sure that the defense has their discovery as soon as possible. So I'm gonna look into this today and make sure that Mr. Mills gets what he needs.
Why aren't people prepared?
The people are unprepared at this time, Your Honor, because unfortunately, our main ATF officer on this case, his child had an emergency surgery yesterday. He was planning on being here. We've been in contact. He's been very participatory, but I did get an email yesterday afternoon that he was going to be unable to make it because of his family emergency.
All right, so,
If I may, Your Honor?
you may.
Thank you, Your Honor. Your Honor, the fact that he's heavily involved here, I think is runs a little hollow. When we were here last time, no one from ATF or anyone else showed up, despite being subpoenaed. I believe we had one officer here, and the people were not able to proceed at that time. The only reason we agreed with an adjournment, despite the people I don't think being ready to move forward at that time either, was because we did want some of this additional information. So I don't know what the officer is saying at this point regarding he really wants to be here. He's already demonstrated his not.
I would understand your concerns. At least it relates to the first failure to appear. I don't know why they would not be present.
There was an ATF officer here, I believe, according to my notes. Officer Arnold was here. That is his, I believe that we needed one or the other was the situation.
Okay, last time you said one, so you needed one or the other, and then why can't we move with one or the other this time?
Because after looking into it further, Your Honor, that is not true. We need this specific officer. So that's my apology for that.
Okay, sounds good. Okay. Under the circumstances, it's outside of the officer's control that his child had an emergency surgery yesterday. I'm going to grant the request for an adjournment. Also, positive, this is a matter that the people would reissue if I dismissed it, correct?
Yes, Your Honor.
So this is going to be reset. July 17th.
Just for the clear record, Your Honor, Detective Arnold is LPD.
I must be getting the name mixed up. It also starts with an A.
No, that's Detective Arnold, but he's with LPD, but he's embedded with a task force with ATF.
So it's complicated.
Can you state your name for the record?
Yes, I apologize, Abigail Wilson for the
Sorry.
people.
Thank you. I don't know. I couldn't tell you what Detective Arnold does. So I'll rely on what they're saying. Either way, the officer they claim they need is not here today due to a family emergency. However, they'll have their officers here next time where the case will be dismissed.
Understood, Your Honor.
July 17th at 9:30. July 17th at 9:30. And then you should have your discovery well before then, because I set this out. Well, even April 11th, there was a concern about additional discovery being sought. April 17th, I was told additional discovery, including body cam, lab reports, and search warrants were being sought. And so here we are a month later and you've not received them. So they need to be turned over immediately.
Just, and Your Honor, if we don't have everything we need at that time, understand that that information is there. I'm going to be moving for dismissal based on violation of discovery at that time.
Absolutely. Any additional matters for the record?
Not on behalf of the people, Your
What's
Honor.
it, 17th?
The
July?
17th, does that work for you?
Yes, 17th at
9:30.
9:30. Thank you.
At 9:30.
Thank you very much.
No problem. Do you know if we're running Gil?
Yes, sir.
Okay, sounds good.
Maybe 3 witnesses, so might run a little bit longer.
I saw Mr. Freeman. Is he still here? Oh, okay, Mr. Freeman? Do you have Hayes here? Oh, Donnie Seaton. Do you have Donnie Seaton?
I have, yes,
Okay, are we running that?
No.
Okay, on the record, in the matter of the state of Michigan versus Donnie Seaton, 24-03053, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
I'm sorry, I'm confused. I beg your pardon. I haven't spoken to this gentleman.
Is he here?
Is that my understanding? I thought we were talking about a Mr. Hayes.
I did ask about Hayes and then I asked about Seaton. Which one are you talking about?
I have Mr. Hayes right here.
Okay, have you spoken to Donnie Seaton?
I've spoken to the prosecutor, and yes,
Is Donnie Seaton here?
I don't know.
Mr. Seaton called and said he didn't know he had to be here.
Oh, okay.
In
Mr.
person.
Seaton's not here yet, then it sounds like. Okay, so you're ready on Hayes?
Yes, Judge.
Okay, on the record in the matter of the state of Michigan versus Valari Hayes, 23-02554 and 23-02495, appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Defendant Hayes. Thank you.
Thank you. Mr. Hayes has 2 files, both scheduled for preliminary examination, controlled substance delivery, manufacturing, and delivery, manufacturing of drugs, and then a controlled substance 3 counts in the other file. How are we proceeding on these?
Thank you, Your Honor. It's my understanding, I wasn't here last week, but that Mr. Palmer requested leave that's set for to treat today as a PCC because he hadn't had a chance to confer his time very well. And so we're here today. I spoke to Mr. Freeman. Mr. Palmer is out. So I believe Mr. Freeman is going to request a waiver for 21 days and have the matter reset for preliminary examination so that Mr. Palmer can further speak with the defendant, but I will defer to Mr. Freeman for fear that I'm saying something incorrect.
The note that I have, I wasn't here last week either. Judge DeLuca presided on this matter in my stead. The initial note was to treat it as a PCC, but then he put another note. Defendant appeared by Zoom. Mr. Palmer now decided to continue to exam. So we're not having an exam?
That's correct, Your Honor.
Mr. Palmer's not here?
Well, no, not standing alone, but his absence does create other problems. I'm not going to divulge in a public setting. I'd be happy to tell the court privately, but there's been some discussions about other ways to resolve the case than simply having a hearing or having a trial.
Oh, so there's negotiations pending on resolution?
Yes.
Okay.
Yes.
Is that?
Yes, I
Okay.
had sent an email to Mr. Palmer with a possible resolution. Apparently he's out of the office now.
Okay. And then is that going to be a global resolution? That's the both files?
Yes, Your Honor. It would be.
Okay. It looks like we are, on the 23 file, Mr. Hayes has already waived the 21 days because he failed to appear previously. And so he's willing to waive the 21 days today.
That would be our intent, Judge.
Is that correct, sir?
Yes.
Okay, so you understand you have the right to have your exam within 21 days of the date that you're arraigned?
Yes.
And because you are negotiating a global resolution, you're willing to waive the timeline? So I can reset it?
Yes.
Okay.
July 18th at 10.
July 18th at 10. That's for both files. We are going to get you a notice to appear while you're here today. But if you lose the notice, it's for your responsibility to stay in communication with your attorney, who's Mr. Palmer, on both files, correct?
Yes, Judge.
To stay in contact with your attorney and to appear to all your court dates, okay? Yes.
Because I've been trying. They say he was sick out last week. I've been calling since I've been out. I haven't got a call back.
I believe if they said he's sick, I believe he's probably not well. So I'm only reminding you because you have failed to appear previously, and then you gave the excuse that you didn't get a notice to appear. but we would have given you your notice to appear while you were present. Because I had a note here on 2023, defendant has a new file, and the defendant was supposed to turn himself in on a warrant. And so I reset this to October 5th, and you didn't turn yourself in on the warrant. So that's why, and that would be this file. So that's why you didn't get a notice to appear, because you were supposed to turn yourself in for the warrant. Okay, but it's your responsibility to keep up with your court dates, okay, sir?
That's what
Okay, so we'll get you notices on both files, July 18th at 10 a.m. Do you have any questions?
I'm-
Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
Nothing further, Your Honor. Thank you.
Thank you. So let me make sure I'm understanding. Is Mr. Seaton on his way or?
On the clerk's office to say he was running 15 minutes late, but.
Well, that was an hour ago. You can't run 15 minutes late an hour ago. Mr. Carter is here. We need one Kane. And then who do we have here again? Love? Mr. Love. On the record in the matter of the state of Michigan versus Tariq Elliott Love, 25-01266, appearance please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Love. He is present with the counsel table.
Okay, Mr. Love was scheduled today for a preliminary examination on assault, murder, assault, robbery, 2 counts, carrying concealed weapons, and 3 felony firearm. How are we proceeding?
Your Honor, I believe that the defense and prosecution have come to an agreement to request an adjournment. In this matter, I believe yesterday there was, we discovered there was an issue with discovery. It looks like there's 5 items missing. Is that correct?
Yeah, I can expound on that, Your Honor. There's a couple issues with discovery. As it relates to the evidence.com materials, the audio and visual files, we have 120, the people have 125. So there's obviously a discrepancy there that we need to work out. And apparently there was also some additional discovery that not only neither side had, but I'm not even sure up until recently that people knew existed. So I received an email this morning that I think likely is the missing discovery that neither side had. It appears to be approximately 250 pages of various reports and records. So obviously we would need additional time to gather and look through all that evidence so that we can be better prepared and I can be in a better position to advise Mr. Love and to be prepared for this hearing. I've spoken with him about the 21-day requirement. He realizes he's entitled to have this hearing within that time frame. My understanding after speaking with him that he is in an agreement to adjourn that hearing past that point to allow us the additional time to get the discovery and prepare for this hearing. So we would be asking for an adjournment of the preliminary examination. For those reasons, stakes are obviously high here. These are light offenses.
Thank you. And Mr. Love, what your attorney says is accurate. You understand your right and you want to waive the timeline? Yes. Okay.
July 18th at 9:30.
July 18th at 9:30.
Fine by me.
Do you have any questions for the court? Any additional matters for the record?
On behalf of the people, Your Honor.
Nothing additional on behalf of Mr. Love, Your Honor. Thank you.
You're all set.
Thank you, Judge.
Thank you. As to Josiah Kane, are we running that one? Was that enough?
No, Your Honor.
Can you bring up Josiah Kane?
You can run it. I don't care. Okay, yeah, I'd like to run, so this one is to include. This one for this one is to include here.
When?
So it would just not, so that one would be.
Not feeling it.
But I really don't care. So I do know. I want to see this first, but that's fine. You don't care.
Yes.
I do not. Super chill. Bar, I had like actually stepped in with it because I did some new shoes I haven't done that with before. But these shoes are just like people are getting like so I feel bad. No, but the George was pretty straightforward. I mean, I don't think so. I mean, we can if that was people company, but I'm familiar with that. Like, what kind of does more and then go.
You know, Hillman.
Like random.
Yeah, but he
reasons. And then when I don't have after today, so when I'm done, I'm done.
Yeah, but we didn't send the church certified so they yeah, except oh she that's where she was doing for it to and so she's just waiting on him to leave.
Yeah.
I told her that
So whatever you need, let me. No. I checked around, so. Yeah. But it's not like there's
it's basically the multiple choice is the same, and then the essays
There are
are
two
just
that
majority rule for all the states. It's not Michigan specific. Mhm. Yeah, they have a JD automatic. Yeah.
You guys think so?
So, yeah.
And I decided that
Yes.
Yeah, I hope not for the first one. So. I guess I'll have a better idea this afternoon.
Yeah, is it working?
I have now an expert. In the language handle. We can run it on next week.
Yeah, I'm kidding. Yeah.
Yeah. She's, I mean, also, I was like, do you want to get out of here? I actually know it. I probably should have waited.
Yeah. Oh. Good morning.
I didn't realize. Okay. That would've went down.
Thank you.
Yes, but it's on the other side of the street as well. Did you see that?
This is on Facebook.
On the record in the matter of the state of Michigan versus Cameron Anderson. And that's 25-01139 and Josiah Kane 25-01210. Appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Josiah Kane, who is present and standing at council.
Good morning, Your Honor. Jacob Sarth, the fourth assistant public defender here on behalf of Mr. Anderson. He's present also at council table. He's standing to my left.
Okay, let's see. My understanding is that both of these matters are co-defendant files were scheduled for preliminary examination on carjacking, carrying concealed as to Mr. Anderson, and then as to Mr. Kane, just carjacking. But I don't know that the people were able to proceed on the carjacking. Is that accurate?
That's correct, Your Honor. The people do not have necessary witnesses at this time to proceed with the carjacking.
I'd ask for dismissal, Your Honor, without prejudice.
Okay, the motion for dismissal without prejudice is granted. The people do have the right to reissue this charge against you. You understand that? Okay, and you're gonna be held on this, correct? Or
He does have something else, but I don't think you're not being, you don't, are you bonded out on your other file? Yes, he is only being held on this.
We'll get you a copy of dismissal in just a moment. Do you have any questions today? Any additional matters on this file?
No, you're right.
Nothing on behalf of the people, Your Honor.
And then as to Mr. Anderson,
Sorry.
Yolanda. You can give him a copy. That's the original. Give him a copy. Okay, and as to Mr. Anderson, what are we doing on that one?
The people are prepared to move forward at this time with the preliminary examination on the CCW, Your Honor.
Okay, and not prepared on the carjacking, so that would be dismissed, correct?
Correct.
Any preliminary matters before we call witnesses?
None on behalf of the people, Your Honor.
He's free to go.
I would just ask for sequestration order, Your Honor. Sequestration order.
Sequestration is granted.
There's only one witness.
We can have a seat.
Officer. Who are you calling? Officer Aaron Bush. Thank you, Your Honor.
I cleared out the call. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, you can have a seat. State your first and last name and spell both.
Aaron Bush, AARONBUSH.
Proceed, counsel.
Good morning, officer. Thank you for being here today.
Morning.
Can you tell us a little bit about your job?
I'm a police officer with the Lansing Police Department, currently assigned to the violent crime issue.
Okay, how long have you been working with LPD?
6 years.
Okay. And were you working on April 15th of this year, 2025?
Yes, ma'am.
Do you recall what happened that day?
Yes. I was looking for 2 subjects who were accused in an armed carjacking.
Okay, and did you find those subjects?
One of them.
Okay, and can you tell me a little bit about that interaction when you interacted with them?
Yep. One of them was identified as Cameron Anderson, and myself and other officers on DCI located him on East Kalamazoo near Mifflin.
Okay, and East Kalamazoo Street and Mifflin Avenue, is that, okay? And is that in Lansing?
Yes.
Is that, so Ingham County?
Yes.
Okay, and Cameron Anderson, is he here today?
Yes.
Can you please point him out and describe an article of clothing that he's wearing, please?
Yellow and brown plaid shirt.
Okay, thank you. Your Honor, at this time, the people would like the record to reflect that officer has identified the defendant, Cameron Anderson.
Any objection?
Thank you, Your Honor. In the interest of issue preservation, I will object. Thank you.
Okay, the objection's overruled. Identification is noted.
Thank you, Your Honor. So when you approached Cameron Anderson, what did you do?
We had, in relation to the carjacking incident, there's probable cause to arrest him, so we were placing him under arrest. And prior to contact him, I saw him, he was displaying our characteristics, but regardless, we were taking him into custody. He was put in the handcuffs, and I searched him to arrest.
Okay, and so when you searched him, did you find anything?
He had before I started touching him, he said, "Y'all got it." That phrase several times.
He said, y'all got it, you said?
Yes, y'all got it, is what the words he used. And so I began searching him, started with the area of his waist, and I removed the firearm from his pants.
Okay, can you describe the firearm that you removed?
It was a black Ruger handgun.
Okay, and did you check to see if Mr. Anderson had a concealed weapons license?
No, I already knew of Mr. Anderson from the prior incident and know that he's under the age of 21, he's not of age to obtain a concealed license.
Great, thank you. One moment, Your Honor. No further questions at this time.
Cross-examination.
No questions, Your Honor. Thank you.
Ms. Witness be excused.
Yes, Your Honor.
Thank you. Is the defense calling any witnesses today?
No, Your Honor. Thank you.
Argument. Argument.
Yes, Your Honor. Sorry, I didn't hear you.
I'm sorry, there's like 3 fans.
No, it's just the heat, I think,
It
getting
is
me.
warm in here, and it's only 10 a.m., so.
It'll only get worse. All right. Thank you, Your Honor. Today, Cameron Anderson's being charged with carrying a concealed weapon. The elements that the people need to meet at a probable cause standard is first, that the defendant knowingly carried a pistol. As the defendant had the pistol in his waistband, I think that it is safe to say that he knowingly knew it was there. I think it's hard for something to be in your waistband and for you to not know it, so especially something as big as a pistol. Additionally, it does not matter why the defendant was carrying the pistol. He just has to know that it was there. Second element that the people have to prove is that the pistol was concealed on or about the person of the defendant. Complete invisibility is not required. However, it does appear that that was the case here. The officer did have to search him and found the pistol, according to Officer Aaron Bush's testimony, tucked within Cameron Anderson's waistband. Therefore, the people have met their burden here and would ask that the charge of CCW is found over the circuit court. Thank you.
Mr. Starks.
Thank you, Your Honor. Respectfully, the burden is on the prosecutor here to show evidence of the elements. And while the burden is quite low, respectfully, defense would still object to the bind over request here, and defense would request a dismissal because respectfully, the people have not met their burden. Thank you.
Thank you. Today was the date scheduled for a preliminary examination. The burden again is on the prosecution. They have to establish sufficient probable cause that the crime alleged in this matter, carrying a concealed weapon, was committed, and sufficient probable cause to charge you as the person who committed that crime. And so this is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need to show me more than mere suspicion that that happened. I think we have that here. I have one officer. I have no reason to doubt his credibility. That's Officer Aaron Bush, who testified on or about April 15, 2025 at the area at or near Kalamazoo in Mifflin, making venue appropriate in this court because it's in the city of Lansing, Ingham County, that he was out in search or investigating a carjacking claim with one of the suspects being identified as the person identified in court here today by the officer, Cameron Anderson. Officers seem to have some familiarity with the defendant because he was aware immediately that the defendant wasn't old enough to carry a concealed weapon, that the suspect, Mr. Anderson, was stopped in connection to the potential carjacking complaint, and then was going to be arrested based on the probable cause of that stop or probable cause of that crime and searched incident to arrest. Some comments or statements were made as to y'all got it multiple times. We can try to surmise a number of things as to what that means. I believe the officer was trying to insinuate that means that maybe they got something on him. Nonetheless, they did locate a firearm or pistol on his person, and it was concealed. And the defendant, again, does not have a weapon, carrying concealed weapons permit. And so the elements have been met. The court will bind this matter over to the circuit court. The bind over date on this matter is going to be the 28th of May. Mr. Anderson, you do not need to appear in court on the 28th of May. That's the date they'll get the file from this court, okay? next court date's gonna be a pre-trial. In circuit court, you stay in contact with your attorney, he'll be made aware of that a date, okay? Do you have any questions at this time? The carjacking is going to be dismissed without prejudice because the people are unable to proceed at this time. They do have the right, though, to reissue that against you if the alleged victim comes forward and is ready to proceed. You understand that?
Yes.
Okay, and then you have a bond, looks like it was 50,000 cash surety. Oh, I amended it, 25,000, 10% with GPS tether and house arrest. I have not received any information or indication that that has not been complied with, so I'm happy to hear that. Bond will continue. Any additional matters for the record?
Not on behalf of the people, Your Honor.
Just gonna request transcripts, Your Honor. Thank you.
Thank you. Did we get him a dismissal on the carjacking?
Commissioner Starks, you completed dismissal on the carjacking?
Just,
Did you-
they have
Oh,
to-
they have to do just one
yeah,
file.
their
Okay,
disposition.
I think they have to do it
Yeah.
Oh, okay, never mind.
because it's not the
Yeah.
whole file. Sorry.
Okay. 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 I'm, you know, I'm gonna make a hard time, so.
I'm waiting for more.
On the record in the matter of the state of Michigan versus Jamarion McCall, 25-00752, appearance please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. McCall. Mr. McCall's presence has been waived, Your Honor.
Thank you. Today was the date and the time scheduled for a preliminary examination. There was assault and murder, multiple weapons and possession by felon. How are we proceeding?
Thank you, Your Honor. So the people became aware of a litany of jail calls between the defendant and the complaining witness in this matter. Because of the number of calls, the people have not had an opportunity to go through them all to determine whether or not they amount to additional charges or forfeiture by wrongdoing. However, at this time, the people will be requesting an adjournment. Additionally, one of the officers that was subpoenaed here for today informed our office that he has military orders for today and was unable to be here. Additionally, another officer texted me this morning and indicated that he has a sick child and was unable to appear today. So at this time, the people are requesting an adjournment, and Mr. McCall has previously waived his 21 days based on the additional contact by Mr. McCall with the complaining witness and the officer's unavailability.
Whenever appropriate, Your Honor, I'll speak.
Yes, you can start this time.
Thank you, Your Honor. First of all, as far as these alleged calls, I have not received any proof of alleged calls. I did reach out to the prosecutor, Mr. Pfeiffer, on this, who did not reply to me. My client was supposed to go to prelim initially on March 27th. I coordinated with Mr. Pfeiffer on April 3rd to have it on May 16th, which is today. My client has been sitting inside 65 days. The officers in question, I found out yesterday at 4:05, could not attend. They're only about the R&Os. My client has been severely prejudiced that he cannot run this prelim today. As I said, Judge, we did schedule around the people once already. He's been sitting for 65 days. I don't think an adjournment's appropriate here at all. And I did just find out yesterday their request for an adjournment.
Okay, I have March 20th. There was a probable cause conference held on the record. The 21 days were waived. You said that was because of the prosecution.
Mr. Pfeiffer said he had a heavy trial schedule and he asked me to coordinate a prelim with him. We were supposed to do a prelim on March 27th. I did coordinate with Mr. Pfeiffer. Him and I talked, Judge.
There's never been a date here for March 27th.
That was communication between me and Mr. Pfeiffer, Your Honor.
Yeah, but Judge Buchanan handled the probable cause conference. She reset the probable cause conference for April 3rd.
Right, and on April 3rd, Your Honor, I contacted Mr. Pfeiffer. He coordinated this date, which is May 16th. And with all that stated, my client's been sitting inside for 65 days. The people do not have the complaining witness here, Judge.
The allegation of jail calls, are they to the complaining witness?
That's correct, Your Honor. Mr. McCall has been using other inmates' accounts to contact the victim at a number that we have on file as her number. Additionally, the jail staff has reached out and indicated that he's been using third parties to reach out to her. They've since disconnected her account to prevent any further contact as of May 1st. Again, based on the number of calls that people have not had an opportunity to go through them or even get them from the jail yet, but based on those communications and the officer's unavailability, we would be requesting an adjournment.
Well, how many calls are we talking about?
It was about 11 pages of calls to her since his arrest.
And Your Honor, I received this list yesterday and I asked for clarification, which the people could not provide at this time. I do visit my client once a week. He's assured me he has not contacted her. I've told him under no, they do have a child that's coming.
Let me stop, because he should have been brought up. This is a bond violation.
An alleged bond violation.
Yeah, he needs to be arraigned on the bond violations. So it's gotta be brought up. Brought the record until he's brought up. He's being brought up now. Okay, somebody said something about Mr. Mills.
I know that was it. I thought it was.
Oh, okay.
They approach.
Yes. Are you approaching about a case?
Yes.
Well, then the prosecutor needs to. On the record in the matter of the state of Michigan versus Robert Darling, 25-00-733 appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Yes, good morning, Your Honor. Brendan Lucia on behalf of Mr. Robert Darling, whose presence has been waived.
Okay, Mr. Darling was supposed to have an exam today on assault with a dangerous weapon and a felony firearm. My understanding now is that the necessary witnesses failed to appear. Is that correct?
That is correct, Your Honor.
Counsel.
Thank you, Your Honor. People being unable to proceed, I would ask for this case to be dismissed.
The case is dismissed without prejudice. The court is relying on you to counsel your client as to what that means, okay?
I will do that
And we'll
post
get you a
haste.
copy of dismissal to take to him.
Thank you very much, Your Honor.
Thank you.
Thank you. Mr. Freeman, do you have Michael Pete?
you, Judge. He just stepped out the hall. He's here.
Are we running?
No, Your Honor, we don't have the necessary
We can
witnesses.
call that one.
Shall I fetch him now?
Oh, it's at the restroom. That's what it is. Is that maybe at the restroom?
Just like when he went down the first-
Did we ever see Mr. Seaton? It's just Donnie, oh, Donnie Seaton. We're ready on Donnie Seaton?
Yes, the prosecuting attorney wanted to go forward.
We're running Seaton? Okay,
Yes, Your Honor.
okay. And then Ms. Schroeder, you have dropping with you?
Yes, Your Honor, and I do not know where he is. I've had very good contact with him, and I hazard to guess that the weather since last night, he did not have power. I don't know what's going on, because she and I, it was gonna be a request for adjournment regardless for, that I did make the court and the prosecutor aware of. But I have no explanation.
Those on Stone Lake?
I have him on Caesar Chavez, East Caesar Chavez.
Oh, okay. Well, he might not have power.
Yeah, that's what my concern is, because I have had.
They're all down Saginaw, that area, the power lines are down.
Yeah.
So I'll hold it for 48 hours.
All right, Your Honor, thank you.
Pretty good.
Mr. Mills,
Yes.
can you approach, please?
That's a mouthful, so. If you're gonna pick one, pick Fortuna, because that one's mine. Gil is my husband, so that one's less important to me.
Yeah. They were left shaped.
Oh, she'll tell him to his face.
Oh, yeah, for sure.
Well, on another note, it looks like you have your client. Oh, you're fine. Let's see. Hold this 48 hours. Okay, on the record, in the matter of the state of Michigan versus Michael Pete, 25-01236, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of defendant Mr. Pete, who stands to my right.
Okay, Mr. Pete was supposed to have an exam today. The charges of assault with intention to do great bodily harm and a domestic violence. How are we proceeding?
Your Honor, at this time, the people do not have the necessary witnesses to proceed.
Counsel?
Yes, Your Honor. Thank you. On behalf of my client, I would respectfully move the court for a dismissal without prejudice, and I would just secondarily respectfully ask the court to address the notion that my client has a tether on his ankle. Thank you.
Motion is granted without prejudice. The people can reissue this against you, and you can go back to Ingham County to have the tether removed. You go to JSG and have it removed. We'll get you a copy. We'll notify them, and we'll get you a copy of dismissal in just a moment. Any additional matters?
Not on behalf of the people, Your Honor.
Anything for you?
It's just any additional matters on this one.
Oh, yes. Nothing further from the defense.
Thank you. Must be a long line for jail, huh? It's still really hot. I thought they fixed the AC.
That's what Mr. Carter was saying, and I was like, I have yet to feel it.
Yesterday was a little bit better, just a little bit.
Okay.
But this is,
Yesterday I was stressed, so.
that was a personal.
Yeah, that
temperature.
was a personal thing, so I was.
It was a little bit
sweating.
better, but it's sweltering right now. Okay. Mr. McCall.
Yeah.
Okay, we're back on the record in the matter against Mr. McCall. And let's see. There was a request for an adjournment by the people. The defense is requesting a dismissal without prejudice. The people intend to reissue this charge.
That's correct, Your Honor.
And there's allegations of a violation of your bond conditions, sir. And so the allegations are that they have a litany or a large amount of calls that were placed from the jail on a recorded line from other people's accounts. I'm talking to you. Okay. From other people's accounts, other inmates' accounts to the protected party. And so when something like that happens, they have to assign a detective. And they go in and they're going to listen to all of these calls to find out what was allegedly spoken about. And so, but those allegations are a bond violation for you if true. And so I'm brought you up because your presence was previously arraigned for the hearing until I realized that there was a potential bond violation. You have the right to have a contested hearing on the bond violation, and you have the right to have your attorney represent you for that hearing. However, if it's determined that you have violated your bond condition, you could be subject to contempt of court penalties. Maximum is 93 days in jail per violation. Do you understand that? And assuming he's pleading not guilty for the purposes of.
Yes, Your Honor, we'll waive any formal reading, stand mute.
Okay, so we will enter a not guilty plea as to the bond violation. As to the request for an adjournment or the request to dismiss, the court's going to deny the request. I don't know, but my records don't indicate why the 21 day, it actually says the 21 days was waived. Not that the court found good cause or that this was something maybe attributed to the prosecution, but that sounds like it was a private conversation that you might have had.
That was Your Honor.
Okay.
And I'm not going to.
Right, yeah, I'm not privy to that at all. What I do know is that Mr. Pfeiffer being a vertical prosecutor, I tend to have to navigate his docket as well because he's in another court. It is what it is. And however, even though it sounds like he still had time to listen to jail calls, even though he probably was in trial. The other issue is that this is a matter that they're just going to reissue. Probably before we can get you back to Ingham County today and have you released, you'll be coming back to be rebooked. That's not a good use of judicial and prosecutorial resources. So it doesn't make sense to do that. The other thing is it's outside of their control that we have two officers, one with a sick child, one on military duties. It's not that the officers just did not want to come. And then now we have accusations of blatant disregard for a court order. I don't know why people would, I'm not saying that this is you because I'm sure you're smarter than this. I don't know why people would be in a jail on a recorded phone call calling people because that's stupid because it tells you that it's recorded. And to think that the prosecutors, maybe in other counties, they don't have time because it's like overwhelming. Maybe in like Detroit, Wayne County, they can't do it. The prosecutors in Ingham County listen to the recorded phone calls, but it's like every time I come here, someone's on the recorded phone call having a conversation, which is the dumbest thing I've ever heard of. But I'm not saying that's you because you're smarter than that, correct? Okay, and so this matter will be set for a and a new preliminary examination date. July 18th or 9:30. Does July 18th work for you, counsel?
Sure, I'm going to be in a capital trial.
You see how those trial schedules can really screw up things?
They really can. Which, and I know my client's sitting, but I can't help the fact that this is a bond violation allegation and I'm in
Agreed.
capital. So, if acceptable to the court, and obviously your schedule is more important to me, is August 1st a possibility? Because I have 3 capitals in July, Judge, and I would like to dedicate all my time to this matter if that's allowed. And obviously, Judge, I'll waive the timeframes on the bond violation, but I do want to study those calls myself.
I might be back. I'm just trying to see if the, I know that I have a conference scheduled, but I'm trying to see when I come back. Does the first in the afternoon work?
I'll work around you, Judge. I appreciate your
I
work
can
with
do
me.
the first in the afternoon.
Like 1 o'clock?
1:30.
Yes.
Any additional matters for the record?
No, Your Honor, thank you.
The only thing I would ask, Your Honor, is if the people are not ready to proceed on the first, I would renew my motion for dismissal without prejudice.
Fair enough.
Sounds good.
Thank you.
Thank you. You're all set.
And Judge, he will look at you. I apologize about that.
Oh, I thought, no, I know that. I thought he was talking to you. So I
No,
wanted him to
no.
know I was talking to you.
He had his hair on his face. I don't
Oh.
want you to think you were disrespected. I apologize.
Thank you.
So he can go. I'm
Yeah,
not.
he can go. Yeah.
Was it?
We dealt with it yesterday. Yeah.
Okay, got it.
I-
And I have no issue. But I do want to kill Adam.
I know. I emailed.
Just gotta get in line. Enforcement, where were you all when I needed 2 people brought up? Mr. Anita, you okay?
I'm living.
No, I get hazmat. I told him about.
It's not stuff outside. It's too hot.
I really don't need this. This is for safety.
You know what happens is.
She
when
doesn't want
people
sick
leave-
people in her
when people leave the
courtroom.
prosecutor's office, it takes them a while for their.
Their immune system to adjust.
adjust.
That makes sense. That literally makes sense. It's been what, 7 days? What's it been?
That'd be my cat. I also was.
Yeah, you got a much stronger immune system.
No. What's going on?
Oh, Dave Anita.
Oh, that's cool.
Wow.
Oh, yeah, I can make that. Okay, on the record, in the matter of the state of Michigan versus Charles Gill, 25-00958 FY. Appearance, please.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Good morning, Your Honor. Stephen notes on behalf of Mr. Gill. Mr. Gill is present and seated to my right.
Okay, Mr. Gill was scheduled today for a preliminary examination on one count of kidnapping. Let's see, 2 counts of criminal sexual crime, 3rd degree, police officer, fleeing, controlled substance possession, a CSC 4, and habitual offense notice. How are we proceeding? You can stand.
Your Honor, it's my understanding that both the people and the defense will be unconditionally waiving their right to exam today. However, that will be to an amended complaint. And I guess what I'd like to do is just kind of walk through each count with the court, just to make sure that we are clear on everything.
Okay.
So count 1, kidnapping would stay the same. Count 2 would be dismissed. Count 3 would be dismissed. Count 4 stays the same. Count 5 stays the same. Count 6 stays the same. For some reason on the complaint, the habitual offender notice is labeled as a count 7 and it shouldn't actually be a count. So I would now then move to add a count 7 of criminal sexual conduct in the 1st degree. Yeah, count 6 stays the same. Count 7 is going to be an added count because it should not be a habitual offender.
Yeah, someone crossed it off on mine, so they can pop it.
Okay. So count 7 will be a CSC 1st under the theory of multiple variables. That is MCL 750.520B with an added second offense notice under 750.520F. Add a count 8, CSC 1st, multiple variables under MCL 750.520B with a second offense notice, 750.520F. Add a count 9, felony firearm under MCL 750.227B/A. Add count 10, felony firearm, MCL 750.227B/A. Add count 11, felony firearm, MCL 750.227B-A. Add count 12, felony firearm, MCL 750.227B/A. Add count 13, felony firearm, MCL 750.227B/A. Add count 14, felony firearm, MCL 750.227B/A. So counts 9 through 14 should be felony firearms, and those would attach to all of these subsequent felonies that are charged.
Okay, just to reiterate, we're discussing counts 2 and 3. All the other counts will remain intact. At count 7, criminal sexual crime in the 1st degree under the theory of multiple variables. The second offense notice attached to that. At count 8, CSC 1st, again, under the theory of multiple variables. And a second offense notice on that, counts 9 through 14, felony firearm.
Correct.
And Your Honor, if I may.
You may.
Thank you, Your Honor. First and foremost, it's also my understanding that people are not going to be seeking additional charges regarding CCW or other charges along those lines at this time. With the way it's really bind over here, Your Honor. I'd also like to inquire of my client if that's okay, Your Honor.
You may.
Thank you. Mr. Gill, I'm just going to ask you a few questions real quick, okay? Now, you and I had an opportunity to talk regarding your rights to a preliminary exam today, right? Yes. And the judge is also going to ask you these questions. I understand that too. But we did talk regarding your right to run it, or even the opportunity to waive the preliminary examination. Is that right?
Yes.
And I informed you that the people would be seeking additional charges. Is that correct?
Yes.
And we had the opportunity to speak regarding your rights even after all of that. Is that correct?
Yes.
Did you have enough time to ask me questions regarding potential bind over versus running the preliminary examination?
Yes, I did.
And it's my understanding that even with the people adding this charge, you'd still like to waive your preliminary examination. Is that right?
Right.
Now, if you have additional questions, did you have the opportunity to ask them?
Yes, I did.
But you feel like you understand what's going on and the
Yes,
circumstances here?
Yes, explain everything to me.
Okay, just want to make sure. Thank you, Your Honor. Appreciate it.
So again, Mr. Gill, you heard the charges that are proceeding to the circuit court, correct?
Yes, ma'am.
And you understand the purpose of the preliminary examination is for the prosecutor to first establish if they have sufficient probable cause that the felonies alleged were committed, and then probable cause sufficient to charge you as the individual who committed those felonies, correct? You willing to unconditionally waive your examination? You understand that once this matter is waived, you can't go to the circuit court, decide that you want to hold your preliminary examination. You understand that? Is anyone threatening you to waive your exam? Any promises if you waive your exam? Okay, the bind over date on this is going to be May 28th. That's the date the circuit court gets the file from the district court, not a date that you need to appear in court. You will not have a court date until they set your pretrial, unless Mr. Milks is filing a motion for you to be rearranged in the circuit court, okay? Do you have any questions at this time? Okay, bond in this matter was set at $250,000 cash surety with GPS tether, victim notification if possible. And you need to report to pretrial services within 48 hours of any release from custody. That will continue. There's also a no contact order between you and the alleged victim. Any additional matters as the bond will continue?
Nothing else from the people.
Just regarding, as part of the waiver here, I think my client wanted me just to inform the court that as negotiations will be going forward here, we obviously didn't want to put anyone through testimony or have to take the stand, Your Honor. We're just hoping that that is reflected at least regarding negotiations. It's nothing for the court here, but we just want to place it right now, Your Honor. Thank you.
Thank you. You're all set.
Thanks.
Thank you.
Thank you.
If you see Mr. Freeman in there, you can tell him to come inside the courtroom. Okay, on the record in the matter of the state of Michigan versus Donnie Seaton, 24-03053. Appearance, please.
Morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender on behalf of defendants proceedings, who is to my right.
Okay, today was the date and time scheduled for a preliminary examination. My understanding is that we're ready to proceed.
That is correct, Your Honor. The people are ready to proceed at this time.
Yes, Your Honor, thank you.
Any preliminary matters?
Not on behalf of the people, Your Honor.
Or from the defense.
I do. What did I do at the bar?
Two.
Sure. If you call your witnesses.
Thank you, Your Honor. The people would like to call Yaria Baker to the stand.
You stop right there and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat, ma'am. There is a microphone that's in front of you, and the lady behind you is the court reporter. So she has to take down everything stated here in the courtroom. So we need your voice to be loud and clear. That microphone will not amplify your voice at all. It just allows the system to pick up what you're saying for the recording purposes. But we have 3 fans running, and then this glass is kind of blocking out some of the sound, okay? All of your responses to yes or no questions must be yes or no. You're doing a good job so far. If you forget, because that's common, we'll ask you, is that yes or no, okay?
Okay.
And then lastly, if there's an objection, you will have to stop speaking immediately. I'll make a ruling on the objection, then I'll tell you if you're allowed to give us that answer or not, okay?
Okay.
State your first and last name and spell both.
Yaharia Baker, YAHARIA
You can proceed, counsel.
Thank you, Your Honor.
1 second. I believe you all are free to go. I think they were just waiting to clear. They were just waiting to clear the defendant. He should be,
In the defendant. Yes.
they should be alcoholic by now. I'm sure they're hot.
They're out of here.
It's a little hot here.
Okay. All right, so it's Yaharia.
Yes.
Okay, perfect. I want to make sure I get that right. I believe I pronounced it wrong on the record before you were here. Good morning. How are you doing today?
I'm good, how are you?
Pretty good. Can you tell me where you live?
I live at 2315 East Charlie Road, apartment 14.
Okay.
Can you repeat that for me, please?
2315 East Charlie Road, apartment 14.
Thank you.
And is that, how long have you lived there?
Since the start of the year, from January.
Since the start of the year? Okay. And where did you live on September 2nd of 2024?
2731 Traffic Code Trail, apartment 1C.
Okay. And is that in the city of Lansing?
Yes, it is.
State of Michigan?
Yes.
County of Ingham?
Yes.
Okay, thank you. And do you recall anything significant happening on that date I just mentioned, September 2nd of 2024?
Yes, I do.
Okay. And can you tell me a little bit about how that started?
I had woken up that morning and I had heard my mom arguing with my sister.
Okay, and what did you do?
I asked my mom, I was like, what's the problem? She told me what the problem was. I had called my sister to try to get the problem solved. She hung up in my face. We have gotten to a mutual fight.
When you say, sorry, I don't mean to interrupt you at any point. I just want to make it as clean as possible of a record and make sure I understand and that the judge understands what's happening. So when, I'm so sorry, my train of thought just went out the window.
They have gotten into a mutual fight.
Yeah, when you say mutual fight, thank you, Your Honor. When you say fight, is that verbal?
No, physical.
Okay, and so how did that start?
I called her. Well, she was originally arguing with my mom to kick my boyfriend out because they had claimed that my boyfriend had touched her a while before that.
Okay.
And I had took the phone to my mom and I had told her, and I tried to explain to my sister that that never happened because I watched the whole thing happen.
Because I'm struggling to hear you and you're actually answering her questions, but it's for me to hear.
Okay.
So if you can turn this way, it'd be helpful.
I'm
Okay.
sorry. No, that's okay.
Okay, you said you said there was a mutual fight. She had been arguing with your mom to kick your boyfriend out, and then I missed some things.
She wanted my mom to kick my boyfriend out because she had claimed that my boyfriend had touched her a while before that.
Okay.
After that, I told her, like, I asked her.
I'm gonna move. That's okay, just so it's less awkward for you.
I asked her, like, do you want to fight? She said she wanted to fight. She came to the house and we started fighting. We broke it up. After that day, she left. And then she came back a moment later with Donnie. Donnie came with a gun.
Okay, when you say Donnie, are you referring to the defendant?
Yes.
Can you point to the defendant and describe an article of clothing?
He's wearing a black sweatshirt.
Okay, and do you know his last name?
Season.
Okay, Your Honor, at this time, I would like the record to reflect that the witness has identified the defendant, Donnie Seaton.
Any objection?
No objection, thank you.
Okay. Okay, so you said that he arrived with a gun.
Yes.
What happened after that?
My mom had been outside because they kind of parked like down the street from my apartment, not directly in front.
Okay.
So my mom had walked down there and she tried to talk to him. I don't know exactly what he said, but after that, he had gotten in the car. My sister had drove past my apartment. He has got out the apartment. He has got out the car, pointed the gun towards me in the window while I was in the apartment, and then pointed up in the air and fired the gun.
Okay, and how did you react to that?
I was scared.
Okay.
And I called police.
And let me just get this clear. Was he in the car when he fired the gun?
Yes.
Okay, okay. That's
Like
fine.
he was like hanging out the window, like, you know how you just hang out the window.
Perfect, that makes sense. Okay, so in the car, hanging out the window, fires the gun, and it's pointed at you?
He pointed at me and then he put it in the air and then fired it.
Okay, so it was fired, pointed at the air?
Yes.
Okay, got it, thank you. And that gun, was it out in plain view the whole time, as far as you know, or?
Not when he first came to the house. When he drove past in the car, yes, it was.
Okay, so not when he first came to the house. Where was it when he first came to the house? Do you
It
know?
was either in his pants or his pocket. It looked like he was in his pocket. He had his hands in his pocket.
Okay, and did you physically see him pull the gun out of his pocket, or you just saw a bulge in his pocket with his hand in his pocket? Can you explain?
A bulge with his hand in the pocket.
Okay, but you never saw him take it out of his pocket?
No.
Okay, got it, got it. So you just saw it when it was pointed at you, pointed at the air.
Yes.
Yes.
My apologies.
I'm sorry.
And then a bulge in the pocket.
Yes.
Got it. Okay. One moment, Your Honor.
No problem.
How about, if you know, how far away what were you from him hanging out the car when he shot the weapon?
I don't really know. I mean, it wasn't really far where I like had to squint to see him. Like I could see him very easily. It was
Further than us,
Yeah, like probably like to that back row.
to the back row.
Yeah.
Okay. I have no idea. I'm so bad at that. 10 feet? Is that about right to the back wall?
Yeah.
Okay. Just because the record doesn't necessarily know how far the wall is, that's all. No further questions for this witness at this time, Your Honor.
Speaker, I'd like to ask you just a few questions to tidy up some of your testimony that you just gave us. What did you say the relationship is between Mr. Seaton here and yourself?
We have no relationship. That's my sister's boyfriend.
Your sister? Okay, so you know him.
Yes.
All right, thank you. Sister, boyfriend. Did you have any communication with Mr. Seaton on the day we're talking about him?
No.
Without telling me what was said, did you notice as to whether anyone else had telephone contact with him?
What do you mean?
Did you see anybody else talking to him on the phone?
On the same day?
Yeah.
No.
No, I'm only talking about that day.
Okay.
All right. Thank you. You say Mr. Seaton pulled up in a vehicle?
Yes.
What kind of vehicle was it?
A white Chevy Cruze or something like that.
Would you describe it as a four-door passenger vehicle or an SUV or something else?
I'm not good with cars. Just like a little sedan or something like that, like a smaller car.
Did you see him exit the car?
Yes.
And where was the car parked when that happened?
Down the street from my apartment complex.
If you know, is there someone that lives down that way that Mr. Seaton is friends with?
No.
Okay. After he parked his car, did he get out?
My sister brought him. She parked the car. After she parked the car, he got the passenger seat.
So he wasn't driving?
No.
No. Was that your sister's vehicle?
Yes.
Ah, okay, thank you. And the car comes to a stop in a parking spot, is that right?
Yes, sir.
Not in the middle of the street, but in a parking spot.
Yeah, in a parking spot.
And Mr. Seaton gets out of the passenger side, I think you told us.
Mhm.
Yes?
Yes.
Thank you. And what did you see happen after he got out?
After he got out, my mom had to get outside to go talk to him. I don't know what was said when they were talking, but after that, he had gotten in the car. After they got in the car, my sister proceeded to drive past my apartment. He got out of the car and he started pointing the gun at me, but then he pointed up in the air and he shot.
So this was after your mother had an opportunity to speak to Mr. Seaton.
Yes.
All right. Doesn't matter if you don't know what they said, I wouldn't ask you anyway. In any event, so he got back in the vehicle drove a little bit further toward your apartment and stopped again.
And then stopped. It was kind of like, I don't want to say a drive-by, but it was kind of like a drive-by, like they were going slow enough to like, he had enough time to point at me, but he instead for firing at me, he fired at me.
How many shots?
One.
And I think you told us that the gun was pointed up.
Yes.
When the shot was fired, the gun wasn't pointed at you, but.
No.
And then the vehicle continued to leave.
Yes.
All right.
Yes.
Did you talk to any family members about your testimony here today before you came to the courthouse?
Only my mother, but she's here too.
Yeah. Did the two of you talk about what might happen or what you might say?
Not about what we might say, but we talk about what might happen.
My last question is, you did not suffer any injuries as a result of what happened that day. Is that fair statement?
Yes, that's fair.
Thank you for your testimony. Thank you, Your Honor.
Anything, man?
Yes, Your Honor. I just want to clarify a few things. So when you say, I believe that you were asked on cross that the defendant drove up. So I just want to confirm, was the defendant the passenger in the car
Yes, he
throughout the
was.
entire, okay.
Mhm.
And who was driving?
My sister.
Okay. And you were also asked about when the defendant exited the vehicle, and I'm just a little bit confused about that timeline. So can you walk me through that a little bit?
After me and my sister.
Whoa.
Sorry,
After.
I thought it was thunder. I was like, take cover.
No, it's the table.
Oh, okay. Sorry.
Calm down.
So sorry. Can you tell me a little bit about, I believe that you were asked about when he exited. I'm just a bit confused because the shot was fired from the car. So can you walk me through the steps?
After me and my sister had gotten into an altercation, she had left the house. She was still getting she came back and parked down the street. She had got out the car. My mom had went down there and talked to him.
Okay.
After that, he got in the car. After that, my sister drove past my apartment, and that's when Donnie got out the window of the car and pointed a gun at me and shot me in the head.
Got it. Okay. Thank you for that. And I just want to clarify, you never left your apartment.
No.
Is that correct? Okay. No further questions, Your Honor.
Thank you. May this witness be excused?
Yes, Your Honor.
Thank you, Ms. Baker. You may be excused.
Thank you.
You can call your next witness.
Yes, Your Honor. People will call Felicia Baker. Yes, Felicia Baker. I know I said that with a bit of uncertainty.
Raise your right hand.
Yes.
Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
I think you can have a seat. So there's a microphone that's in front of you, and the purpose of that microphone is simply so that the lady behind you can hear what's being stated on the record, but it does not amplify your voice for the rest of the courtroom. So if you can keep your voice loud and clear, that'd be wonderful, because we have a couple of fans going. As you can tell, it's warm in here. And the other thing is, all of your responses to yes or no questions must be yes or no's. We can't really jot down mm-hs and uh-hs or head nods and head shakes, okay?
Yeah.
If you forget, we'll remind you or ask you if it's a yes or no. Lastly, if either attorney objects, it requires me to make a decision on whether or not that answer can be given. So you will stop speaking so I can make that ruling, and then I'll tell you if you can give us the response or not, okay?
Yes.
Okay, thank you. And state your first and last name and spell both.
Her name is Felicia Baker, and it's spelled Felicia. Last name is B as in boy, Aker.
Thank you, Your Honor. Good morning. Do you recall anything significant occurring on September 2nd, 2024?
Yes.
Can you tell me where you were that day? Do you know the address?
Yes, 2731 Trappers Cove Trail.
Okay, and where is that to you? Like, what is that address to you?
That was my home.
Okay. And did you live with anybody?
Yes.
Who did you live with?
My husband, Gregoni Baker, my daughter, Yaharia Baker, and her boyfriend, Darian Allen.
Thank you. So can you tell me a little bit about what occurred that day?
I was talking to my fourth daughter on the phone about some events that was taking place. And my youngest daughter came out and saw the text messages on the phone, and they began arguing on the phone about the boyfriends and stuff.
And then what?
Then my fourth daughter, Maya, came over to my house, and Yaharia and Maya got to having an argument and tucking it in the house.
Okay.
And I tried to break it up. And then somehow it transferred outside the house. And then that's when I was outside the house.
Okay, I was gonna say, when did you go outside?
I went outside after my two daughters were tuckling each other. I was trying to tell my youngest daughter to stay in the house and my fourth daughter to go home to her house. And I was outside being, trying to get her to go home.
Okay, so you're saying their scuffle?
Yeah.
Kind of went outside and you followed them?
No, the stuff will stop out in the house.
Okay.
And then I went outside to my fourth daughter and told her to go home, and my youngest daughter remained in the house.
Okay, thank you for that. And then what happened next?
Then my youngest daughter boyfriend came out on the porch, and my oldest daughter got upset that he was out on the porch, the front porch of the whole apartment complex. And I'm trying to tell her to go home, go home, go home. And I'm trying to tell him to go back in the house. I'm trying to just de-escalate the situation and go home and go home.
Is that boyfriend the one that lives with you?
Yes.
Okay, perfect. And did she go home?
No, she went towards the boyfriend, and they got to scuffling outside the house. And then they fought just a little bit or here and there, you know, and then my youngest daughter came outside when that started happening, and then I broke it up again, and I told her, please go home, go home. She did go home after that.
Okay.
Everybody was in the house and everything happened, you know, was kind of upset about everything that was transpiring. Then I received a call from my daughter. She said that, can I come over and
can I just clarify which daughter?
Maya.
Okay, and that's the one that does not live with you?
Correct.
The one that you told to go home?
Correct.
Perfect. Keep going.
She came, she texted me, asked me, could she come by? She had lost something, her hair or something. She has alopecia. She was wearing a wig at that time. And I said, you know, sure, you know, that's no problem. I'll meet you outside to help you find that. So her and my youngest daughter Yaharia wouldn't get into another argument or scuffle.
And when she arrived, what happened?
When she arrived, I saw Donnie get out the car, holding something, you know, like in his pocket. And I was standing there, and he was like hollering, you know, you gonna beat up my girlfriend, I'm down for mine. You know, and then he what appeared to me like a gun. And that's like, no, you need to put that away. You're not doing this today. You need to just go home. Just go home.
Okay, and when you say Donnie, do you know his last name?
See.
And are you referring to the defendant?
Not a friend, just acquaintance with him, with my.
Right, I apologize. I think that I probably didn't speak clear enough. Are you referring to the defendant?
Oh, yes, I am.
Okay,
Sorry.
No, you're totally fine. But that answers my next question. So that's good. So you told him that we're not doing this today, and how did he react to that?
He just kept arguing and fussing over me because at that time, my youngest daughter, Yaharia, and her boyfriend, Darian, was outside arguing, fussing, and I told him, no, you need to go home. And at that time, my daughter pulled up, and he got in the car. And then at that time, I was still standing outside. He fired a shot up in the air. Well, no, take that back. He pointed the gun at the window where my daughter was looking outside the window, because I told her, go back in the house. And I said, do not come outside, because he got, you know, he has a gun. And he pointed the gun at the window where my daughter was looking out of. And then as they were racing away, he fired a shot in the air.
Okay, and then just for clarification, because there's two daughters present. Who's the daughter in the car?
My fourth daughter, Maya.
Okay, and the daughter that you told to go back in the house?
Yaharia.
Okay, perfect. Thank you. And did anything else occur after that?
No, they went on about their business. I called, my youngest daughter called the police
Okay,
and we just told our story, what had happened.
okay. And was he in the car when he fired the shot?
He was hanging out the window. He got in the car and had called out the passenger side window. And as they were driving away, he raised his arm and fired up in the air.
Okay. What kind of car?
It was a white Chevrolet car.
Okay, and about how far away would you say the car was from where you guys were standing?
I guess about maybe 20 or 30 feet. He was right, the way the apartment buildings are is a grassy patchy area between the two apartment areas. So I was saying
Sure.
maybe right before he got to the second set of apartments, that's when he fired up the gun.
Okay. No further questions.
Cross-exam.
Yes, Your Honor, no questions. Thank you.
Your Honor, may this witness be excused?
Yes, ma'am. Call your next witness.
The people have no further witnesses, Your Honor.
Thank you. Is the defense calling witnesses? Mr. Freeman, are you calling any witnesses?
Not today, Your Honor. Thank you.
Thank you. To proceed to argument.
One moment, Your Honor.
No problem.
Thank you, Yolanda. Okay, thank you, Your Honor. The people are ready to proceed with argument. Today, the defendant is charged with discharging a firearm from a motor vehicle, carrying a concealed weapon, and then a felony firearm. Additionally, the people are seeking to add a felonious assault and subsequently an additional felony firearm after the testimony that was given today. For the discharge of the, let me pull up the charge sheet so that I'm going in order. I have a habit of not doing that. So count one, the discharging a firearm from a vehicle, the people have to establish, I believe that the people have established sufficient probable cause. The first element that we had to show is that the defendant did discharge a firearm. We have testimony from both Yaharia and Felicia that the defendant did discharge that firearm. The second element, into the sky, that one shot. Additionally, the second element is that this was done on purpose. The testimony that we heard today does indicate that that was done on purpose, that there was an intentional moving of the firearm to the air and a shot as it was driving, as the car was driving away. The third element is that it was done from a motor vehicle. We heard testimony today, again, from both Yaharia and Felicia, that while the defendant fired the firearm, that he was hanging out of the passenger seat of a white Chevy Cruze as it was driving away slowly. The fourth element is that the firearm was discharged in a way that endangered someone else. I do believe firing a firearm into the air is endangering the people around. We do know that there were people outside at the time as well. As far as the second count of carrying a concealed weapon, the elements include first that the defendant knowingly carried a pistol, Obviously, the defendant knowingly carried the pistol if he had pointed it and then fired it. We do have testimony from 2 witnesses today that appears credible. Both witnesses did testify that the defendant did have a weapon, and that they did see something that resembled a weapon in the pocket before the weapon was pulled out. The second element is that it was concealed on the person of the defendant. Of course, we have the 2 witnesses who saw the bulge in the pocket beforehand of the defendant. So we do believe that that establishes probable cause. And then I need the element for the added charge, which would be because count 3 is a misdemeanor. Count 4 is a felony firearm. So of course the defendant, when committing the discharge from the vehicle, did have a firearm. So that would be the felony firearm.
What are you requesting to add?
Felonious assault.
Oh.
I'm just struggling to pull up the 17.9 element, but I'm gonna have them in 2 seconds. Okay. So the charge that we wish to add is a count 5 of assault with a dangerous weapon. The first element of that is that the defendant either attempted to commit a battery on, this would be Yaharia Baker, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. We believe that this occurred when the gun was pointed in Yaharia's direction. The second element of assault with a dangerous weapon is that the defendant intended either to injure Yaharia Baker or to make Yaharia Baker reasonably fear an immediate battery. We do believe that people have established probable cause for this because when the defendant pointed the gun at Yaharia Baker, that would cause a reasonable person to fear an immediate battery. The third element is that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought that he had the ability with a firearm in hand, that satisfies that element as far as the probable cause standard goes. And the fourth element that the people have to satisfy is that the defendant committed the assault with a dangerous weapon, the dangerous weapon in this case being a firearm. And then additionally, there would be a count 6 added here. That would be an additional felony firearm for the felonious assault. So all that being said, Your Honor, people would request that all of these charges be bound over to circuit court. Thank you.
Your Honor, I regret to inform the court, I don't have my copy of the complaint with me. May I just inquire of the court as to whether the CCW is a vehicle or? In a vehicle. All right, thank you. The only objection I bring to the court's attention is that the defendant is, at the start of this hearing, is charged with brandishing in public. We heard some testimony from the first witness that would suggest she testified that the gun was pointed at her, and the prosecutor picked up on that and wants to now add a count of felonious assault. I'm not really going to object to the addition of the felonious assault, but I think that at the same time causes us to disregard the brandishing in public. I don't think I think they're one and the same. She felt endangered. She felt concerned for her welfare because of this, I guess, pointing a firearm at her. Well, that's, before we started the hearing, that was brandishing. So I think that the brandishing needs to be dismissed if the people continue to want to add felonious assault based on the facts that we heard today. Thank you.
Okay, so today was the date scheduled for preliminary examination. It's the burden of the prosecutor to establish that they have sufficient probable cause that the felonies that were committed were actually committed, and then sufficient probable cause to charge you as the person to have committed those felonies. This is not a trial. They don't have to prove each element beyond a reasonable doubt. we are not addressing misdemeanors at this matter, only the felonies. And then the burden is more than mere suspicion that these crimes were committed. You were charged in count 1 with weapons, firearms discharged from a vehicle, and the prosecutor did go over those elements. Again, the elements being that the defendant did discharge a firearm from a motor vehicle. Second, that he did so intentionally, that means on purpose. And that third element, again, that it was from a motor vehicle. Fourth, that he discharged the firearm in a way that endangered someone else, caused physical injury, or caused serious impairment to a bodily function, or caused death. And so in this particular case, we've had testimony first from a Yaharia Baker and then second from a Felicia Baker. Their testimonies are quite consistent with one another. But again, understanding this Yaharia Baker being the alleged victim in here, in this particular case, stated that on or about September 22nd, September 2nd, that is 2024, at the area of 2731 Trappers Cove, that's in the city of Lansing, Ingham County, state of Michigan. That makes venue in this court appropriate. She identified the defendant in this matter, Donnie Seaton. Through testimony, it's understood Mr. Seaton to be the boyfriend of Miss Baker's sister. Miss Baker, Yaharia Baker, that is, testified that she woke up on that date and time, and she woke up to her mom arguing with her sister. The basis of the argument having to do with Mr. Seaton needing, or them wanting to have Mr. Seaton, no, my apologies. The argument was about Miss Baker's boyfriend wanting to kick her boyfriend out the house. The court's not aware of that boyfriend's name. Nonetheless, mom arguing to kick boyfriend out the house because of the claim that that boyfriend, who's unnamed, allegedly touched the sister of Miss Baker at some time previously. Miss Baker, Yaharia Baker, and her sister engaged in a mutual, well, it sounds like a phone conversation, and then she was invited to engage in a mutual fight, to which the sister showed up for two sisters to fight. And then the sister left. And then it's sometime later, the testimony is that the sister returned, this time with her boyfriend, that boyfriend being Donnie Seaton, and that Mr. Seaton made some comments, and the comments, or the nature of those comments, were brought in through testimony by Felicia Baker, something to the effect that you're gonna beat my girlfriend up, I be down for mine, and that he discharged a weapon. That was testimony consistent between both, or that he pulled out a weapon, I should say. That was consistent between both Felicia and Yaharia Baker, that there was a weapon displayed, or an item that resembled a weapon, a firearm, that being pulled out of the vehicle. It's my understanding that Mr. Seaton was a passenger, but maybe at some point switched, but the car was moving and it slowed down. He fired the weapon in the air after pointing the firearm at Yaharia, defendant driving or in the vehicle of a white Chevy Cruze. There's sufficient probable cause as to the elements that was read for weapons, firearms, discharge. And so that will be bound over to the circuit court. Again, the elements for carrying concealed weapon in a vehicle requires that the people prove beyond a reasonable doubt at trial, first, that the pistol was in the vehicle that the defendant was in. Second, that the defendant knew the pistol was there. And third, that the defendant took part in carrying and keeping the pistol in the vehicle. Again, the testimony is that the defendant pulled up in a passenger side of a white Chevy Cruze, which is a vehicle, and that he had or possessed a firearm, a pistol in his hand. And obviously, based on that, the court can ascertain that he took part in keeping or carrying that pistol in the vehicle. There's sufficient probable cause as to count 2, carrying concealed weapon, that will be bound over to the circuit court. Count 4, weapons, felony, firearm, based on the allegation that the defendant possessed a firearm when he had committed or attempted to commit, in this case, the charge of discharge from a vehicle. And so that there's sufficient probable cause based on the testimony to bind over count 4. People are asking to add a count 5 felonious assault or assault with a dangerous weapon. Mr. Freeman argues that to add the felonious assault, it somehow contradicts the brandishing. Whether or not that's true, the court's not going to even get into that because I don't have to address misdemeanors at a preliminary examination. But based on the testimony, which is that the defendant appeared with a firearm, made some statements that he be down for his, and then pulled out a firearm and pointed it at the alleged victim, there's sufficient probable cause as to the elements. First, that the defendant attempted or committed a battery upon Yaharia Baker, and that he did the act that would cause a reasonable person to fear in it or apprehend immediate battery. Someone pulls up to my house and pulls out a firearm and says, I beat up their girlfriend and they are down for theirs. I would assume that they're here to shoot me. So I would fear immediate battery. So that element is satisfied. Second, that the defendant intended to injure the complainant, that being Yaharia Baker, or make the complainant reasonably fear an immediate battery. I don't believe, based on the testimony, that he intended to injure Ms. Baker, but I do believe he intended to make her fear an immediate battery. Why else would you show up after allegedly there being a fight that his girlfriend must have gotten beat up, if that's the statement he made, with a firearm to her sister's home, but for the fact to instill some fear. Third, that the defendant had the ability to commit the battery or appeared to have the ability or thought he had the ability. I think based on the testimony, all of those are relevant and present in these facts. Fourth, that the defendant committed an assault with a dangerous weapon. It's undisputed that a pistol is a dangerous weapon. The request to add count 5 of assault with a dangerous weapon is granted, and that will be bound over to the circuit court. So the complaint with 5 counts will be bound over to the circuit court. Bind over date is May
Your Honor.
28th.
I'm sorry to interrupt you. There was also a 6th count felony firearm.
I'm sorry, the felony firearm to accompany the assault with a dangerous weapon will be added based on the testimony. Those 6 counts will be bound over to the circuit court. The bind over date is going to be May 28th. You, Mr. Seaton, do not have an appearance date on May 28th. That's the date the circuit court gets the file from the district court, okay? Do you have any questions? Any additional matters for the record?
Not on behalf of the people, Your Honor.
Nothing further.
Bond will continue as well as a no contact order. You're all set.
Thank you.
You're welcome.
Oh, thank you. Thank you.
Yeah.
Thank you.
Thank you.
Yeah, I would. Yeah, I would. I usually use it to. Yeah. Holds on trials and it's.
Oh, boy, let's see. Are we finished before 12?